I am Professor Maheshwar Singh. I am teaching at National Law University, Delhi. I am Professor of Political Science as well as the Director for Center for Studies in Disability and Law. I primarily teach political theory and international relations at National Law University, but also teach some subjects which has interface with political theory, jurisprudence and public law, for example, law and justice in globalizing world at the postgraduate or LLM level at the National Law University, Delhi. Today I'm going to be speaking to you about the role of law and Indian judiciary. I'm going to be sort of dividing my entire conversation with you in three important parts. First is, what are the principles of rule of law? How does Indian Constitution envisage rule of law in various of its articles? And to what extent judiciary has been an important institution in promoting the idea and instilling the consciousness of rule of law among Indian citizens. So therefore, to start with, I would say that democracy is a form of government and democratic role is sustained by concepts like rule of law, separation of powers between different branches of the government and independent judiciary. So therefore, the framers of the Indian Constitution duly recognized rule of law as an important pillar of Indian democracy. And judiciary has been assigned a vital role in upholding the principles of rule of law, and it does so by interpreting the Constitution of India. What are the principles of rule of law? The doctrine of rule of law embodies the message that howsoever high and mighty one may be, law is above all. It emphasizes the principle of the supremacy of law. The essence of rule of law is to preclude and prevent any arbitrary action by the state authorities. Therefore, if that is the central idea of rule of law, we must be able to know what are the features of the principles of law. Let me just give you a brief history about the origin of the concept of rule of law. It was first developed by Sir Edward Coke, the Chief Justice in James I reign, and he originated the concept and propounded the idea of rule of law. Subsequently, Professor Dicey developed it and gave a distinct meaning to the concept. He listed three important features of rule of law. First is preemption and prevention of exercise of arbitrary powers by the state authorities. Number two is equality before the law. Number three is courts acting as a guarantor of liberty of the citizens. And number four, which is most important insofar as the functioning of the principle of rule of law is concerned, is the independent judiciary with the predominance of legal spirit within the system. So therefore, the rule of law requires that the rule should be general, abstract and known to all, certain and apply equally to all the citizens. Now, constitutional government presupposes a prior commitment to the freedom following the principles of rule of law. An essential feature of constitutional government is legal limitation on the governmental action. Therefore, the constitutionalism is a guarantee to uphold the principle of rule of law. In other words, what we're suggesting is constitutionalism and rule of law are two sides of the same coin. They cannot be seen as mutually exclusive, rather they function in tandem with each other, in togetherness, in order to give meaning and life to the legal system. Now, having outlined the important principles and features of doctrine of rule of law, I'm going to be speaking to you about Indian Constitution and rule of law. Now, a country that follows the principle of law would be one where the grundnorm of the country or the basic core law from which all law derives its authority is the supreme authority of state. For India, the grundnorm could be taken or understood as the Constitution of India. That Constitution of India is the core law, basic law from which all other laws, rules, and legal principles derive its sustenance within the jurisdiction of India. Therefore, we can say that our laws derive its values, legitimacy from the Constitution of India. Now, rule of law is not defined in the Constitution of India, yet the Supreme Court of India, in cases Indira Gandhi versus Raj Narayan and S.P. Gupta versus Union of India, declared that rule of law as the basic feature of the Constitution. It is also differently called as part of the basic structure doctrine of the Constitution of India. Now, basic features of the Constitution, rule of law being one among the several, cannot be removed by constitutional amendment. So, whatever is part of the basic structure doctrine of the Constitution of India cannot be annulled by constitutional amendment. It will remain for as long as Constitution of India remains functional or the grundnorm insofar as the governance of the country is concerned. Now, rule of law is so central to Indian constitutional governance that the phrase rule of law occurs over 1,000 times in judgments of the Supreme Court of India since 1950 to the present. And we are talking about a span of 70 years, and in variety of judgments, the Supreme Court of India has used the expression rule of law, though it is not defined anywhere in the Constitution. Hence, rule of law is viewed as an idea which promotes the idea of justice, fairness, inclusiveness, and remains integral to good governance of India. All of these values, for example, justice, fairness, inclusiveness, is part of the preamble of the Constitution of India. The fundamental rights included in Part 3 of the Constitution of India, and it has come under the purview of doctrine of rule of law, which are enforceable by law. Now, all articles within which are enshrined in Part 3 of the Constitution of India are, if violated, any of the principles are violated, the citizen can immediately rush to the court of law, and therefore they are justiciable. If any law made by the legislature under the jurisdiction of India, which is against the mandate of the Constitution, the law would be void. The Constitution of India guarantees equality before the law, an important aspect of rule of law, and it is enshrined in Article 14 of the Constitution of India. In any of the articles enshrined in Part 3 of the Constitution, if violated, then the citizen can go to the Supreme Court and High Court under Article 32 and Article 226 of the Constitution of India, which is the writ jurisdiction of the High Courts and the Supreme Court. Here, the term law includes, and it's important to mention in course of my conversation with you, the term law includes orders, rules, regulations, bylaws, notices, and customs. Under Article 32, the Supreme Court has the power to issue writs in nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. It is also given the power of judicial review to prevent any ultra-virus law to preserve and uphold the principle of rule of law. Article 15 and 16, likewise 14, speak about right to equality. Article 19 and 20, freedom of speech and expression, and 21, Article 21, in form of right to life and liberty, are the provisions of our Constitution, all right, which uphold the principle of rule of law. However, there are some exceptions. The President of India and the governors of the state under Article 361 have been given special exemptions. For example, armed forces personnel are treated under armed forces law and in some situation, armed forces are given some immunities. For example, we can speak about Armed Forces Special Powers Act, which are imposed on disturbed area. But these provisions are also made by laws under various provisions of the Constitution. Therefore, the rule of law remains an abiding principle of government as much as for a poor person to the wealthiest, including the powerful constitutional functionaries. The sum and substance of the Constitution of India, which rule of law remains at its heart, argues that everyone falls within law's empire. Therefore, the point that I was trying to put across for your consideration was the importance of independent judiciary, all right, in order to uphold the rule of law. Because judiciary is the final interpreter of the Constitution and constitutional provision, especially Part 3, which and many of the articles deal with rule of law. The judicial pronouncement given at least by the Supreme Court is final and has a binding value of law. Fortunately, right after independence and after the promulgation of the Constitution of India, judiciary has functioned as an important organ and has always emphasized on upholding the principles of rule of law, which is so important for democratic functioning of India as a country. For example, the decisions given by the Supreme Court of India is so much valued that the Supreme Court of India is looked up as a model court in various jurisdictions in South Africa, in UK, in United States. Such is the prestige of Supreme Court, and that has happened because the judges of the Supreme Court have largely remained independent in their legal reasoning, have largely remained uninfluenced. I will speak about some of the landmark judgments handed down by the Supreme Court, which involve the high and mighty of this country to uphold the principle of rule of law, which is the axis of, which is the heart of the Constitution of India, if you like. So, for example, the first landmark case happened during emergency, and this case is called the ADM Jabalpur case and versus Srikant Shukla. This case finds mention in any legal text or all texts, even sometimes in social sciences text. All right. The case sort of occurred during emergency, and it involved various articles of the Constitution of India, for example, Article 14, 20, 21. So the question that the court was confronted with, and in this case the apex court was confronted with, whether there was any rule of law apart from Article 21, which is right to life. Justice H.R. Khanna, in his dissenting opinion, observed that, and I quote, even in the absence of Article 21 in the Constitution of India, the state has got no power to deprive a person of his life and liberty without the authority of law. Without such sanctity to life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning, unquote. And therefore, the point Justice Khanna is trying to put across is whether Article 21 existed in the Constitution or not. And it does exist, Article 21, upholding the right to life. The life of citizens, the nature of citizens cannot be taken away under any circumstances through unlawful action. The second important case, which is very well known case, which is the case is this was dealt once again by the Supreme Court of India. This is called the Keswanand Bharti case versus the Union of India. In this case, the court declared the rule of law is one of the most important aspects of the doctrine of the basic structure of the Constitution of India. Likewise, in Menka Gandhi versus Union of India, the Supreme Court declared that Article 14 strikes against arbitrariness. Hence, Article 14 seeks to establish the rule of law. And another very important case, and I must tell you about this. This is between the then Prime Minister of India, Indira Gandhi, and Raj Narayan. This case is called Indira Gandhi versus Raj Narayan. And in this case, Article 329A was inserted in the Constitution under the 39th Amendment, which provided immunities to the election to the office of the Prime Minister from judicial review, meaning thereby the election of the Prime Minister cannot be judicially scrutinized by any court. All right. The Supreme Court declared Article 329A as invalid since it abridged the basic structure doctrine, and rule of law is part of basic structure doctrine of the Constitution of India. Likewise, another case which is a very important case, this is Benaki Zinc Limited versus Kerala State Electricity Board and others. This is a 2009 case. In this case, Justice S.B. Sinha, the then judge of the Supreme Court, declared, and I quote, "It is now a well-settled principle of law that rule of law inter alia postulates that all laws would be prospective, subject to course of enactment and express provision, indentment to the contrary." Now, likewise, another case which is a very important case insofar as the doctrine of rule of law as part of the basic structure doctrine of the Constitution of India is concerned is Gadak Yaswantrao versus Balasaheb Vikhye Patil. And probably you know the two parts of any judgment, ratio and miscendi. The ratio laid down, and I quote, "If the rule of law has to be preserved as the essence of democracy in which purity of election is a necessary concomitant, then for democracy to survive, rule of law must prevail, and it is necessary that the best available men should be chosen as people's representative for proper governance of the country." Another landmark case, Singh versus State of Punjab. This case is widely reported. Justice Bhagwati had emphasized that rule of law excludes arbitrariness and unreasonableness. To ensure this, he suggested that lawmaking power of the legislature must not be unfettered. All right? It must be tempered with within the purview of law, and he emphasized the need for an independent judiciary to protect the citizens against the excesses of executive and the legislative power. Another important case in the Supreme Court in P. Sambamurthy versus State of Andhra Pradesh declared a provision authorizing the executive to interfere with the tribunal justice as unconstitutional, characterizing it as violative of rule of law, which is clearly the basic structure, part of the basic structure, and an essential feature of the Constitution of India. And likewise, I can go on speaking about other cases in which the apex court has over and over again emphasized the significance of rule of law in the functioning of democracy. For example, Yusuf Khan versus Manohar Joshi is another case. And in this, the Supreme Court made the state a duty bearer to preserve and protect the law and the Constitution, and declared that it cannot permit any violent act which may negate the rule of law. Now, the point that I'm trying to make here is plain and simple, that through the cases that I've cited and I've discussed in course of my conversation with you, it becomes evident and crystal clear that the apex court has not held itself back, all right, in sort of asserting its independence and upholding the principle of rule of law as part of the basic structured doctrine, or part of the Grun norm, if you like, insofar as constitutional governance in India is concerned. On the above discussion, we can say that the courts keep on reinventing legal reasoning and legal strategies by which it enjoins upon the government not only to function within the parameters of law, but also create favorable conditions which may help people develop capacities to enjoy the rights in proper and meaningful way. Despite the persistent effort by the Indian judiciary, the doctrine of rule of law in the Indian society has not achieved its intended effect. However, I must say that it has raised the consciousness of the people towards inspiring, which has inspired the values of the Constitution, all right, and spirit of legalism in the minds of people. One such example is the judicial innovation, like the public interest litigation, which has done away with the idea of locus standi. What is locus standi? That if you're not party to the case, you have no cause to go to the court. But in public interest litigation, public spirited individuals, all right, despite being affected or not affected by a situation, can take the matter to the court. So in this way, the point that I'm trying to put across is that the Supreme Court of India has really expanded the horizon, if you like, through its judgment, all right, of the concept of rule of law and a rule-based society. Thank you so much for giving me a patient hearing. Thank you.